Hi, I'm Attorney Iworski. How are you?
Good, how you doing?
Good. So I'm covering for Attorney DeCroce today. So you're scheduled for a sentencing hearing today on the disorderly conduct, and then you were scheduled for a trial on the breach of bail charge, right? Is that what you have as well? Okay. So what we're going to do today is we're just going to go forward with the sentencing hearing. I'm not going to go forward on the breach of bail. You were convicted on the disorderly conduct. I don't see a reason to pile additional charges onto you. So you'll be sentenced on the disorderly conduct, and then we'll be done today. Okay?
So you're dropping the breach of bail?
I am. Yep. Okay. And I spoke with the trooper about it, and he's fine with that.
Good,
Okay?
good. Thank you so much.
All right. Sound good?
Yeah, no problem.
All right.
All set?
Yep.
Pretty dead, Frank.
Yeah, well, I mean, there's no way. I got the law right here, right? So, I didn't create danger, obviously, which is why this has been dropped, and I didn't commit a felony, okay? I'm being persecuted for exercising my First Amendment.
You and I just didn't we just have
Because I'm here today for nothing. That's why I'm getting angry.
You're here for a sentencing hearing.
Yeah, I know. And I got found guilty of disorderly conduct for less than what I'm doing right now.
Okay.
For being loud.
Okay.
Because I have a loud voice. So I got found guilty of disorderly conduct for having a disability because I get excited.
This moment is an early preview of the storm that's coming. Notice how Frank reframes the entire situation. Instead of acknowledging the conviction, he claims he's being persecuted for simply having a loud voice or being hyper. This is a common tactic in sovereign citizen and pseudo-legal circles. Take a legal consequence and turn it into a civil rights violation. But here's the key. Disorderly conduct isn't about volume. It's about behavior, escalation, refusal to comply, and causing a disturbance that requires a police response. Courts look at intention, context, and impact on public safety. By reducing it to, "I'm just loud," Frank is skipping over the real issue, his conduct, not his decibel level. Ask yourself, do you think he's genuinely confused about the charge, or is he trying to reframe the narrative to avoid responsibility?
And I was found guilty, yeah. I had my day in court, and what was I found guilty of? Why am I not under arrest for disorderly conduct right now?
Sir.
Why am I not under, hey, listen, don't give me no directives, you're just gonna make it worse. Ridiculous.
Hey, Frank.
Absolutely ridiculous.
Frank, was the breach of bail when they arrested you here? Was that one, or was it a different one?
Judges on the way.
Yes.
We'll wrap this up and you'll be on your way.
That was the one, thank you. That was the breach of bail for the New Hampshire 9 arrest. For where someone was arrested for saying amen. And I was arrested for, we don't know yet, making a loud noise, which is all on video, and I didn't make one fucking peep. Not one fucking peep.
Yeah, well, we would know if you had.
You're in a courthouse.
I don't care, it's not illegal to swear, okay?
If you
I don't need,
disturb
listen,
other
have me
people-
arrested, do something. Do something.
I don't want to.
Do something, because you can't.
I'm trying to work
Don't
with
give
you.
me directives and tell me what to do or what to say or anything.
Right here's where we see the classic behavioral shift. Frank begins rejecting even the simplest instructions. In most courtrooms, interrupting the judge or raising your voice is enough to land you in contempt immediately. But instead of escalating the situation, the attorney and staff keep attempting to de-escalate, giving Frank every opportunity to regain control of himself. What's striking is how he mistakes patience for weakness. Each attempt to calm the situation is interpreted as an attack or a challenge to his autonomy. This mindset, "don't give me directives," is the hallmark of defendants who spiral not because the system is against them, but because they refuse to participate in the process. Let me know in the comments. Do you think the court should have stepped in sooner? Or was patience the right call here?
Trying to, but these people, they all want to take their time. Oh, hey, oh, just calm down, let it be cool. No, this is absolute bullshit why I'm here today. And everybody knows it, and that's why you dropped those charges.
I told you what.
So I get it, you're cool, you dropped the charges, I appreciate that, it's nothing personal against you.
Then be
This
cool
is
to me
business.
like I'm being cool.
I am being as cool as I can be,
Frank,
okay?
come on, Frank.
You wanna get this done?
Oh, I'm ready, let's do this thing, I've been here, let's go.
The priest will enter.
All right, honorable court is now in session.
All right, morning, everyone. Thank you.
This is one of the most important clarifications so far. Frank keeps arguing he's being punished for free speech, but the prosecutor's explanation reveals the actual issue. Location and conduct matter. The First Amendment protects a wide range of speech, but it does not protect showing up at someone's home, a place where they have a heightened expectation of privacy, and shouting at their family. Courts consistently rule that targeted harassment at a residence crosses a legal line. Frank frames himself as an activist, but the court sees a pattern of behavior designed to intimidate or provoke. Regardless of political opinions, the legal distinction is crystal clear. Freedom of speech doesn't mean freedom to disturb, threaten, or disrupt private individuals in their homes. Would you feel comfortable if someone did this outside your house?
Please be seated. All right. And this is State versus Frank Staples, docket number 435, 2021 CR 240, and dockets number 435, 2021 CR 1692. Attorney Jaworski does appear on behalf of the Newfields Police Department. She's filling in this morning for Attorney DeCroce. Mr. Staples does appear. He is self-represented. We are scheduled this morning for a sentencing hearing in the 2021 CR 240 on the Class B disorderly, and then additionally the matter is scheduled for trial in the breach of bail charge. Are we ready to proceed?
Judge, we're going to go forward on the sentencing order. As I told Mr. Staples, the state police are here. I had an opportunity to speak with them. Although we are ready for trial, I think in the interest of fairness and equity, he's been convicted of the underlying disorderly conduct charge, so we're going to use prosecutorial discretion.
How is it underlying with the breach of bail?
Breach of bail charge, and we're just going to go forward on the sentencing hearing with the disorderly
Okay,
conduct.
all right, very good. And then I will give you that one. Oh, wrong one. I gave you that one. This is the breach.
That's somebody different.
All right, thank you.
Thank you.
All right, so with that then, if we're ready, we'll proceed with the sentencing and the state's recommendations. Mr. Staples, what I'm going to do is I'm going to hear from the state first, what they're recommending relative to the disorderly conduct, which was a Class B misdemeanor in that matter. And then after I hear from them, I'm certainly going to hear from you as to any recommendations or any position you take as to penalties, okay? So with that, thank you, Attorney Jaworski.
Judge, the state's going to ask for a $1,000 fine, $500 of that to be suspended for 2 years good behavior. Your Honor, heard the facts and circumstances of this case. This is an individual who has racked up similar charges to this recently.
Frank's reaction here reveals something fascinating about how he interprets consequences. He proudly points out that charges against him get dropped, as if that negates the pattern of confrontational behavior. But legally, dismissals can happen for many reasons: lack of evidence, prioritization of resources, or strategic prosecutorial discretion. Yet instead of taking that as a warning sign or an opportunity to adjust his behavior, Frank treats it as vindication. That mindset is dangerous in a courtroom because it leads defendants to believe the rules don't apply to them. This also shows the court's dilemma. How do you impose accountability on someone who refuses to acknowledge any wrongdoing, even when the evidence is overwhelming?
Prior conviction for bail jumping in 2013, on February 11th of 2013. It looks like he had 1 to 7 years for a sentence with counseling, mental health treatment. He had a possession of prescription drugs also in 2013 where he was convicted. He had multiple counts. He received a 12 months time served sentence in that particular matter. He had a possession of a controlled drug with intent to sell conviction in, looks like 2004 out of Hillsborough.
When is my sentence over? When is the crime done?
Yes, Mr. Staples, please, I'm gonna hear from you also.
Yeah.
But she gets to recount what she
Fine.
wants,
She
so,
can do whatever she wants.
thank you.
Another possession of controlled drug with a 9-month sentence. Shoplifting conviction in 97.
I was 17!
Mr.
A juvenile!
Mr. Staples,
So she's bringing up my juvenile.
Here's a teachable courtroom moment. Frank believes that mentioning his juvenile record is unfair or improper. But the prosecutor isn't using it to increase his sentence. She's using it to illustrate a lifelong pattern of similar behavior. In sentencing, courts are allowed to consider criminal history because it helps them evaluate future risk, compliance likelihood, and rehabilitation prospects. What's even more revealing is how Frank fixates on perceived slights instead of focusing on the issue at hand. He reacts emotionally rather than strategically. A seasoned defense attorney would redirect the conversation, highlight mitigating factors, and argue for leniency. Instead, Frank turns every fact into an insult, which only weakens his position and reinforces the prosecutor's argument. Do you think representing himself helped him, or made everything worse?
What's really going on here?
Mr. Staples, do I need to take a break? Let's just get through,
Let's get through it then.
telling me what she wants to recommend and about your
And
prior-
why? Because of all these past crimes all the way back to when I was 17?
All
Get
right.
the fuck out of
Stop.
here.
And please with the language. Attorney Jaworski.
Judge, he has a robbery conviction in 97 out of Hillsborough South with a 12-month suspended sentence. That's the first half of his criminal record. He does have an additional 6 pages, but I won't go through every detail. I am asking for a little bit of an enhanced fine, although I am asking that half of it be suspended for 2 years good behavior. Also, part of that good behavior is that...
Not paying shit. Believe that.
Get,
Mr. Staples.
make sure we have the address. They would not be allowed to respond to that same address with a disorderly conduct of the judge.
Okay, Mr. Staples, you've heard the recommendation of a $1,000 fine with 500 of it suspended. Do you wish to be heard on what you're asking the court to impose within the limits of the maximum amount?
Yeah.
12.
This is where the legal misunderstanding becomes undeniable. Frank keeps revisiting the verdict phase, insisting the court justify the finding of guilt, even though that phase is already over. Sentencing isn't the time to debate evidence or argue innocence. That's what trials and appeals are for. By pushing the conversation backward, Frank reveals a fundamental misinterpretation of how the justice system works. And the irony? The judge is actually giving him helpful information. His right to appeal is preserved, and he can challenge the conviction, just not today. But instead of seeing this as a procedural safeguard, Frank sees it as another attack and responds with escalating hostility.
Cause any sort of pecuniary loss or any damage or anything like that. And I also am asking you to reconsider your finding of guilty because I will be appealing this. I'll put you on notice. And I do want to know exactly what did I do to commit disorderly conduct, because it was nothing even like what I've been here today in this courtroom. Okay? I didn't do anything that was disorderly. I asked why I was being threatened to be arrested. The man never asked me to leave the area. You've seen the video. He lied in his testimony. So I want to know why I was found guilty to begin with. What? You need to articulate yourself.
You've had your opportunity.
$0. No penalty whatsoever.
Okay, thank you. And I've heard your testimony and listened for several hours at the trial, and I've issued that, and certainly you do have the right to appeal, and I will expect you to do that. So with that, I will adopt the state's recommendation. I will impose a fine of $1,000. $500 of that will be suspended for a period of 2 years for your good behavior.
Put me in jail now then, $50 a day. Let's go. $50 a day in jail because I ain't paying shit.
It's 150 now.
So
150, whatever. We do $10 a day. Let's do it.
don't sell yourself short. Are you able to pay the $500 fine? I'm sorry, yeah, $500.
I ain't paying no $500 fine.
All
You
right.
gotta be kidding me.
So you know there's an additional time payment fee of $25 that gets added.
Don't care, I ain't paying.
This is the moment where Frank's strategy, or lack of one, completely collapses. Instead of negotiating, offering context, or requesting alternative sentencing options, he flat out refuses to pay anything. Judges handle thousands of cases, and the fastest way to lose any remaining sympathy is to reject every lawful option presented to you. Refusing to pay a fine doesn't make it disappear. Courts have structured alternatives, including payment plans, community service, or, in extreme cases, jail time equivalency. But Frank insists on framing this as a battle of wills, as if defiance will magically erase the consequences. Ask yourself, is this principle or pride?
Down that it'll be paid in full within 30 days, in addition to...
Say whatever you want to say,
That's what it'll be.
okay? Ain't gonna happen.
We'll be in recess. Thank you. Good
Yeah.
luck to you, Mr. Staples.
Thank you. Have a bunch of bullshit.
Probably have a bad day.
Huh?
Wish him a bad day.
Yeah.
Amazing. You told her you weren't going to pay, and she's like, well, we'll put you on a time payment.
We'll put you on time. Put me in jail now!
They don't want to put you in jail.
Let's go.
Put me in jail now! 5 years in solitary confinement, you get fucking fined, $500 fucking fine, get the fuck out of here.
I love how they brought in the
Unbelievable,
SWAT
you bring up all that fucking record too. I changed my life, I have a fucking business where I help people reintegrate from prison and from rehab and from homelessness. And you what, when are my past crimes done with? When do I live it down?
You already know the answer to that, Frank.
Never,
Never.
right?
Let's go. Come on.
We feel it's right around. Bunch of bullshit. Hope you feel real good about yourself.
I don't think I've ever heard of anybody paying fines, any activists. It's funny, they think they get us and they don't.
Let's do it. I love this game. We could play this all goddamn day.
They just want to bring him back in for another hearing.
Yeah.
And with that, we reach the end of one of the most chaotic sentencing hearings we've seen in a long time. What this case illustrates is simple. Self-representation requires discipline, focus, and respect for courtroom procedure. 3 things Frank struggled to maintain. The judge showed remarkable patience. The prosecution laid out a clear and factual pattern of behavior. And the sentence, a fine with half suspended, was far more lenient than many courts would have imposed given his conduct. Instead of demonstrating remorse or understanding, Frank escalated at every turn, turning what could have been a simple proceeding into a full-blown confrontation. In the end, his refusal to pay, his refusal to listen, and his refusal to accept responsibility didn't change the outcome. It only reinforced why the sentence was justified. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.